Hi, guys. It's Christine here. So, I want to talk to you today about a decision that just came out granting the University of Toronto an injunction to remove the pro-Palestinian, anti-Israel protesters who have set up a fenced-off encampment on the grass in front of campus at the University of Toronto in King's College Circle. I actually went to see the encampment last week after watching 2 days of hearings where the university was arguing that the protesters were trespassing. And the protesters were arguing in response that their encampment was constitutionally protected expression. So I wanted to see the encampment for myself before the decision came out because I thought there was a good likelihood that the judge would grant the injunction. And one of the reasons I thought that this would be the outcome is, first of all, this to me seemed like a clear trespass case. And the University of Toronto owns that property. And the other reason is because the case law suggests that the charter actually doesn't apply to universities. Now, I had a blog post last week on my website, christinevangeyn.ca, where I described my experience visiting the encampment site. And I said in that blog post that I thought that the case law suggests that the charter does not apply to the university. And a few people were curious about that. They asked, why doesn't the charter apply? It surprised people to hear that I thought the charter wouldn't apply. Well, the decision is out, and it came out yesterday at about this time yesterday. And the judge said that he doesn't actually even need to consider the question of whether or not the charter applies because the protesters messed up their procedure. They made some procedural mistakes. But he said even if they hadn't messed up their procedure, he would still find that the charter doesn't apply. So that was what I was expecting. So he granted the injunction and on the basis of trespass. And he said that the protesters have until 6 p.m. on Wednesday, July 3rd to leave. So that's in about an hour and a half from now, from when I'm filming this. So the police have said that if the protesters do not leave that site, that they will enforce the injunction. And from what I have seen on Twitter, I saw Sean O'Shea, who is a global news reporter. He said that the protesters have said that they will not leave. So I guess soon enough, in about an hour and a half, or maybe longer, depending on when the police move in, we will probably see videos of a police showdown. So there are a lot of really interesting issues in this case, but the one that I want to focus on is the finding that the charter does not apply to the university. So let's get into it. As you know, I'm interested in protests and protest movements, and I've been following this one for a while. As I've said before, I think you probably know that I don't agree with the cause of these protesters, but we don't prohibit or permit protests on the basis of whether or not we agree with the cause. The right to freedom of expression is content neutral. But the question, I guess, is, does the right to freedom of expression apply here? So certainly the university has made a policy commitment to the values of freedom of expression, and they should. Universities are places of debate and discovery and truth-seeking, and expression that makes people uncomfortable is actually well suited to university campus, where you go to learn and have ideas challenged and kind of find the contours of the answers to life's big questions. But this is a commitment that the university made. And the university has also said that they want to use the green space on King's College Circle to balance the expression of everyone on campus. And currently, they can't do that. It's occupied right now by a small group of protesters who have commandeered fences to block the whole area off. They control entry to the area. They have guards, their own protesters acting as guards, posted at the entrance and around the perimeter of King's College Circle. They question people who want to enter. They say anyone can enter. They did allow me to enter, but I think it's because they seem to think I'm media, and I guess I sometimes am media. But one of the things that they require is a commitment that you support the right of resistance, which it kind of does suggest that there is an ideological screening that they're doing in allowing people to enter. Now, the protesters say that the reason they have this screening is to keep altercations out, keep out people who might cause an altercation. But one of the things that the judge said in this granting the injunction is, why should the protesters have the ability to control how the space is used, to control who can go onto the green space, when the university, who's actually the one who owns the property and wants to use it, why can't they enforce their rules, but the protesters get to enforce the protesters' rules? So this system where the protesters have commandeered the whole space to the exclusion of others, that is not allowing for debate and discovery. The university says it's a trespass on their property, and the judge agreed that this is the tort of trespass. Now, the protesters said that removing them, granting the injunction to remove them, would violate their right to freedom of expression guaranteed under the charter. Now, the judge disagreed with this, and he first said that there was a procedural problem. So let me explain that. Now, normally when you want to make a charter argument like this, you need to take a specific procedural step, which is called serving a notice of constitutional question. And you serve that on the attorneys general, the federal attorney general and the provincial attorney general. And this notice of constitutional question informs the attorneys general of an issue that allows them, that there's this issue, and it allows them to make submissions orally or in writing. It gives them a seat at the table, because there could be an impact on the government. Even though this is a dispute between the university and the protesters, if the Constitution is being argued, the attorneys general will want to know so that they can make their voice heard as well if they decide they want to. And in this case, the protesters were responding to a challenge of the application of the Trespass to Property Act, as well as the common law tort of trespass, when someone is trespassing for the purpose of exercising expression. That was their argument. And this is the sort of issue that the judge said he thought that the attorneys general would probably be interested in. So a notice of constitutional question needed to be served. So he said that the protesters having failed to serve this notice, he declined to even address the question of if the charter applies. So this is good advice to counsel, to make sure you file your notice of constitutional question. But then he did something kind of funny. He said that in the event that he's wrong about the procedural issue of notice, he would still nevertheless consider the question of whether the charter applied. And he concluded that it doesn't apply. And he did this in an appendix to the reasons. He said that he wanted to put it in an appendix so that it didn't interfere with the overall narrative of the decision or confuse people. And he said that this was because the question of whether the charter applies or not actually doesn't make a difference to the final outcome. Because even if the charter did apply to the university, he said the restriction on the protesters' use of the green space in King's College Circle, finding that there was a trespass, that's a reasonable limit under Section 1 of the charter. So a lot of people, when I wrote about this originally, they said that they were surprised that the charter doesn't apply. Are you surprised? Let me know. Leave a comment. I am obviously not surprised. There's a good amount of case law that has actually considered this question. And, basically, it generally does not apply. Sometimes in very specific circumstances, it can apply, but this, to me, didn't seem to meet those conditions. So let's look at what the court said. It examined a bunch of this case law. There's an important case from 1990 called McKinney and Guelph, and that involved the University of Guelph and the question of mandatory retirement age. Some professors and librarians had said that mandatory retirement was discriminatory. And the court concluded that universities do not perform functions of government because the manner in which they are organized and governed gives them legal autonomy and ensures they are not controlled by government. The court then revisited this in another case called Eldridge in British Columbia, where the court held that the charter would only apply if the university is government in its nature by virtue of the degree of control the government exercises over it. And we know that universities are autonomous and self-governing. And in Eldridge, the court said it could also apply if a particular activity of the university is government because, for example, it implements a specific statutory scheme or government program. And in fact, in order to pursue the goals of academic freedom, the university actually requires independence from government. So it would be at odds to say that the university is government. So The University of Toronto meets neither of these. The university governance model in Ontario means that universities are not government actors, and decisions about the management of the university, including its property, they are not made to further any specific government policy. And there's a case from 2012 involving Carleton University in Ottawa. It's called Lobo and Carleton, and it was a Court of Appeal decision that found that a university decision about when and how its property is used, that does not engage the charter. So that is very on point for this particular case. And the court in this case would be bound to follow an Ontario Court of Appeal decision like Lobo. Now, there are a few two Alberta cases where the charter was held to apply, but those are really, really different. The conclusion in those Alberta cases was reached after looking at a different statutory and regulatory scheme that exists in Alberta. And in Alberta, it appears that universities are under more immediate government control and direction than universities in Ontario. And in fact, in that Lobo and Carleton case, the court looked at those Alberta decision, or one of the Alberta decisions, and they rejected the approach when the court found, and they rejected the approach. Then they said that, Alberta is different. Their statutory scheme and regulatory scheme is different. The charter still doesn't apply to Carleton. So likewise, the court in this case would be bound to follow that precedent. There's uncontradicted evidence from the University of Toronto that it's independent of all levels of government. And in fact, the university needs to be self-governing in order to uphold and promote the goals of academic freedom and carry out its core mission. So one last point that is kind of interesting and I think important is that it's something my colleague Josh DeHaas has written about. He wrote about this case in the National Post a few weeks ago, and he argued that the encampment is not expression. It's a tort, and it's the tort of trespass. Now, similarly, punching someone in the face, you may think that is expressive, but it is not protected expression under the charter. It is a tort. And likewise, trespass is a tort. It's not protected expression. So the court in this case seemed to agree with that sentiment. And they wrote in the appendix that even if the charter applied to even theoretically, if the charter did apply in concept to this university, it doesn't apply in this case because the charter doesn't protect the tort of trespass. So that's the charter analysis. The judge called the charter issue a red herring because ultimately the injunction could be granted without even considering the charter. And it could be granted on the basis of the irreparable harm caused by the trespass to property, including the inability to recover anything financially from the people involved in the trespass, anything from the protesters. But to me, the judge said it's a red herring. He doesn't even need to consider it. But to me, this was probably the most interesting part of the case. And the result was entirely consistent with everything that I expected based on the case law. Now, you may be wondering about a few things. First, enforcement. So the police, as I have said, they have stated that they will be enforcing the injunction, and that means that they will move in on the encampment and disassemble it. And depending on how the protesters respond and how they act, this could result in altercations, which could lead to criminal charges. I'm not giving any legal advice. Just this is standard legal information that altercations with police can result in criminal charges. So when I visited the encampment on Friday to ask the protesters who were there what they planned to do if the injunction was granted, it actually was quite difficult to get a response to that question. First, because there were not very many protesters when I went on Friday, maybe 10 people inside and 10 people out max. I assume that they're going to bring in more people. Maybe not, but I assume there will be more than 20 people that I saw there on Friday. The other reason it was difficult to get an answer was because the protesters just didn't want to tell me what they planned to do. The most I got was one student told me that whatever they decide to do, it will be a collective decision. it doesn't seem to be a very good idea to me, because criminal sanctions can have lifelong consequences that are borne by the individual and not by some amorphous collectives. And individuals could bear those for life. They could bear those consequences for life of a criminal charge and conviction. People have different situations where having a criminal conviction or criminal charge could have very different implications for them, depending on, for example, their immigration status. So deciding what to do as a collective when the individual consequences are born and where they can vary dramatically doesn't seem like a good idea to me. But from what I read on Twitter, they wouldn't answer me when I asked what they're planning on doing. But Sean on Global News said that he tweeted out that the protesters have said that they will plan on staying. So I guess we're going to see in the next, hour and 15 minutes now what happens with police enforcement. We will see enforcement. We may see arrests, depending on how the protesters react. Now, another question that you might have is, why is the result of this injunction different from the result of the McGill and Concordia injunctions? There were similar protests at those universities, and those injunctions were not granted. Now, the court in this case talked about that. They considered those two injunctions. And the main difference is that this is an interlocutory injunction, and those Montreal cases were interim injunctions. And there's a lot more notice and a much fuller record in an interlocutory injunction like this one. So in this case, the protesters had a lot of time to respond. They had a lot of notice. They did respond. They produced thousands of pages of material. So there was a much fuller record. One thing that's also really interesting is, the change in perspective on whether or not the charter should apply in this case. Now, my colleague Joanna Barron has written about this in a piece coming out tomorrow in The Hub. You should go and read it. If you don't subscribe to The Hub, it's really excellent. So she's written about how the perspective on whether or not the charter should apply has really shifted along ideological lines as the culture war has shifted. So in the current cycle of the culture war, it's progressives who are arguing for the charter to apply to universities because they want these pro-Palestinian, anti-Israel protests to continue. But ironically, a few years ago, at the this kind of zenith of peak woke, it was conservatives and free speech fundamentalists who were arguing for speech protections to extend to universities and fight back against disinvitations to speakers at universities and predatory investigations. So just a few years ago, it was actually conservatives who wanted the charter to apply. Now, a lot of conservatives seem to be arguing against it, and progressives are arguing that it should apply. I think that that's interesting. I think that it's important to have a consistent rule that doesn't vary depending on what you think of the content of the protest. But I'd be interested to hear what you think. Do you think that the charter ought to apply? I think that another important thing to think about when you consider whether it's a good idea for the charter to apply is that, in my view, treating universities as government and government institutions raises concerns about academic freedom. These are but as a broader statement, freedom of expression and assembly, these are important values that ought to be upheld on campus, whether or not the charter applies. And the distinction in this case is about the trespass, about the occupation with the fences and the prohibition that the protesters have made on people entering the space. So the decision makes it very clear that protesters are entitled to continue to protest. They just cannot erect structures or camp overnight. So I'm curious what you think is going to happen. Do you think that the protesters are going to clear out on their own? Do you think we're going to see police enforcement? Do you think the charter should apply? Do you like the idea that there's a consistent rule? Or, I don't think many people would admit to wanting the rule to shift depending on if they agree with the subject of the protest. But if that's what you think, let me know. It's kind of interesting. Someone wants to admit that. I thought that it was really interesting in this case that the judge did the analysis when he didn't actually have to. And I think that seemed to be because people are so interested and invested in this case. He was really conscious of the audience. he wrote the decision in terms that were easy to understand for a lot of people. So I'm looking at the comments now. I love seeing everyone engage. I guess we're going to find out soon what happens. And if you are interested in hearing more about the work that we do at the Canadian Constitution Foundation, you can visit the ccf.ca/freedom updates. We send regular updates about our ongoing legal cases and about other interesting developments in constitutional law. And of course, subscribe to the channel. I don't always give notice when I'm going live like this, but I thought because this is all being dealt with in real time and it's going to happen, really soon, just over an hour from now, it will be interesting to talk about it live with you guys. All right. Thanks everyone for watching, and let's keep fighting for freedom in Canada.